Owiti for the state. It is an application that is brought under Article 29 of the Constitution and Article 49, 1A1.
So it's under articles?
Articles 29 and 49 of the Constitution. And it is our general submission that there are absolutely no grounds for the Honourable Magistrate to have arrived at the decision to order that our client, the applicant, be held for a further 12 working days. And that decision of the Chief Magistrate was arrived at following the consideration of the notice of motion by the Directorate of CID, which is found at page 6711, which is dated 29th of August 2000. I respectfully request the court to turn to that notice of motion. The notice of motion in itself does not make any sense. It is a reflection that the Directorate of CID do not appreciate the change of the law regarding custody of persons they consider suspects. It asks the court to allow Inspector Maxwell Otieno to hold the suspect, Sarah Wairimo Kamotho, in police custody for a period of 14 working days to enable him to conduct investigations as to the disappearance of her husband, Cohen. The constitutional restriction on holding suspects in custody is 24 hours. I repeat, 24 hours. It is not 24 working hours, 24 hours on a working day, 24 hours on a weekend. It is simply 24 hours. If you arrest a person on a Friday at noon, you must release him on Saturday at noon. If you arrest somebody on a Sunday, you must release him on Monday. Mr. Maxwell Otieno wants a period of 14 working days, which amounts to 2 weekends, so plus 4 days. That would be weekends within those 14. So he's effectively asking for 18 calendar days. And he seeks, or he sought, no order to permit him or his team to involve her in any way in those investigations. I'll quickly turn to the order that he was given. The first order he was given will be found at page 74. 74 is the order that was given by the Chief Magistrate pending the delivery of the ruling. And he said the suspect will be remanded at Muthaiga Police Station, it's at page 74. And that the respondent suspect may access her house if she needs or so requests under escort of the investigating officer, and her lawyers are at liberty to accompany her. And that the ruling will be delivered on 2nd September 2019. What did he get? Just an order that she'd be detained. Detained for the sake of it, because he got no orders to permit him to involve her in any part of his investigation. In other words, it was needless, unconstitutional detention. After arguing the application, another order was obtained. And I just wish to use the terms of that order. It's at page 89. And with great respect to the Chief Magistrate, the order was as absurd as the application with regard to the period of detention, the term of detention, and the purpose of detention. Page 89, that order reads, the suspect, in brackets respondent, be detained at Muthaiga Police Station for a further 12 working days from the date of this ruling. What did Mr. Otieno get? He only got permission to detain her at a police station called Muthaiga, and for no purpose that relates to his own investigation in relation to her. So that, may I carry on before that? 12 working days is what he got, instead of the 14 he saw. So you don't count the 4. He got no permission from the court to detain her on weekends. Saturday, Sunday not being government working days. In fact, I should say, when I asked his colleague, Inspector Mwangi, to have her visit on a Saturday or Sunday last week on Friday, Mr. Mwangi said, it is not a working day. He does not work on Saturdays. She is a mabus. She waits for Monday. So that the order we seek to review is useless for the purposes of investigation. He cannot have access to her. He cannot ask her to assist him in any part of his investigations. But certainly she will feel the weight of being held in custody by the Kenya Police or the DCI. I should state at this early stage, following her arrest on the 28th of August, the applicant exercised her right to remain silent on advice of her advocates. So that now that she's a suspect under arrest, even if Maxwell Otieno gets an order that she be detained indefinitely, she will say nothing to him. She will sign no document of his. She will not investigate herself. So it is absolutely worthless, except a clear violation of the Constitution. The further order he got was that the police are at liberty to secure the matrimonial home as a scene of crime to which the suspect may access if need be or at her request, but under the escort of the investigators, and that her lawyers be at liberty to accompany her to the said matrimonial home during such access. And finally, the suspect to be brought to court. My Lord, the magistrate correctly observed that there is no order required to declare a place or a location a scene of crime. To this minute, this second, as we sit in this court, the DCI, George Kinoti, and his team, with or without consulting the DPP, have not, and I repeat, have not secured the home of the applicant as a scene of crime. Have not. How serious are they? How serious are they? In short, in simple terms, it is a joke that Mr. Otieno comes to court and asks for permission to secure a scene of crime or a scene of alleged crime. Let us now quickly examine the grounds that he brought before the Chief Magistrate and see whether they meet the test. In the notice of motion at page 67, Mr. Maxwell Otieno went to the Kiambu court, and before I go very far, I wish to say the home of the applicant, therefore the place he is alleged to have, her husband is alleged to have disappeared, is in the Lower Kabeta area within the Nairobi County. And your police station is? The police station is Spring Valley. Why? And I ask this question, why? Because no answer has been provided. Why did Maxwell Otieno, Inspector, go to Kiambu to file this notice of motion? No answer has been given. It remains a big question. Is it convenient? Is it a case of forum shopping? Is it the court that they are more comfortable with? Why? No answer is given in the affidavit. Yes, this is our application. And it arises the same quorum as the morning. No, now we are not much separate. They have taken away the ladies' state council. Maybe they can explain.